those who don't know me, my name is Josh Blackman. I'm a law professor in Houston, Texas, which is relevant here. I'm the president of the Harlan Institute. I started this competition about 12 years ago. And sort of evolved in unexpected, back to my good friends. It sort of evolved in an unexpected way. When I graduated law school, I started a Supreme Court Fantasy League. People would predict Supreme Court cases. It wasn't anything that I thought would be a big deal, but it sort of went viral overnight. 1,000 people signed up in one day. And then what I discovered was that many high school teachers were actually using the Supreme Court Fantasy League to teach their kids about the Supreme Court. They'd actually have their students make predictions. And the teacher said, it'd be really helpful if you help to, explain these cases to teenagers. Like, oh, that seems like a good idea. So I started writing lesson plans about these cases. And then I said, well, might also be cool to have students, write blog posts about the various cases. And we started doing that for a year or so. And then I said, well, why not just write blog posts, write briefs? So we actually had students writing appellate briefs for the pending cases. And then about 2012 or so, I had an idea that it might be really fun to actually do a competition over Skype at the time, where kids at different schools could argue cases. And it really grew organically. And we've had the championship round on Zoom. And starting in 2013 or 14, I can't remember when, we actually had an in-person championship round. It was actually in Philadelphia the first year at the National Constitution Center, which is a great venue for everyone. It's a really good place to visit. And then after that, we said, well, let's do it in DC. And my good friends at the Georgetown Supreme Court Institute were kind of open the doors. We've had it here ever since. And they started working at Supreme Court Experience. We have a tour of the court at noon today. So after we go, we'll celebrate and to the highest court in the land and to the highest court in the land, as it were. So I'm very grateful to have so many really bright and talented students. We've had over 400 students participate in this competition over the last decade. Some that are actually going out to law school and clerking already. So it's sort of gives me a great sense of satisfaction to see young men and young women so interested in the court and the Constitution and just grow up and thrive. Also very grateful to have judges, Judge Maggs, Judge Lambert, and Judge Toro, who give up their very, very busy time to help evaluate the sessions today. So we have two teams. I'll ask them to introduce themselves. Petitioners.
Morning, judges. I'm Kevin Bisley from the Blake School in Minnesota.
I'm Maxwell Steinberg from Riverdale Country School in New York.
I'm Nathaniel Marks from Regis High School in New York City.
I'm Edward Napoli from Regis High School in New York City.
Very good. And just these two were participating remotely. They never met in person until today, which is actually kind of remarkable. I also want to thank the parents and the teachers. I know how much work goes into these sorts of competitions. The coaches, the parents, and teachers do a lot of the hard work behind the scenes. So thank you all so much. All right. Any questions before we get started? All right. I will call the court to session. You all know the phrase. You don't have to rise. It's fine. You get to that. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention. The court is now sitting. God save the United States and its honorable court.
Counsel, you may proceed.
Mr. Chief Justice, and may it please the court. The First Amendment's broad protection of the freedom of speech and expression defends just that, expression. Because social media companies' content moderation cannot be seen as expressing anything at all, Florida is free under the First Amendment to regulate it and compel factual disclosures about how a platform's terms of use are applied.
The First Amendment's guarantee of free speech and expression has made for a nation of free discourse, but the social media world, which this court recognized is the new public square in Pakenham, is an entirely different story. At present, social media companies like those represented by respondents hold absolute control over what can be said on their platforms, which allows them to censor contrarian views and ideas they disagree with without any accountability. To bring these unfair content moderation policies into the light, Florida passed SB 7072 in 2021.
The 11th Circuit found the law to infringe upon the free expression of social media corporations and impermissibly compel speech. We ask that this court reverse the decision below for the following reasons. Firstly, the content moderation of social media companies is not speech itself, but only regulations concerning the hosting of a third party's speech. Cases such as Miami Herald and PG&E concerned instances where editorial discretion was used to determine which speech could be posted in the first place. Under Pruneyard and Fair, which much better fit the passive posting of speech as on social media, then content moderation is not expressive. Furthermore, the common carriage doctrine of the English common law allows the imposition of non-discrimination requirements such as SB 7072. Because the law in essence serves to require fair moderation on platforms, it is clearly within the scope of this doctrine.
Florida's disclosure provisions are perfectly consistent with this court's holding in Souter, which allowed states to compel purely factual disclosures about the terms under which their services will be provided. And lastly, respondents brought a facial challenge to this law, and this law plainly has a legitimate sweep as applied to companies like Uber and Gmail. And for these reasons, we ask the court to reverse the 11th Circuit and uphold Florida's law. We welcome your questions.
Counsel, I have a question. Much of your argument turns on the issue of whether the speech is the social media company's speech or the speech of the customers who use it. Is that a question of law or a question of fact?
I think it's a question of fact, generally speaking, and I think what we can see is in these social media companies' terms of service themselves, they disclaim any responsibility for the speech at issue here. In context of like for federal law for protection of these social media companies, they disclaim any ability for responsibility for this speech. So on one breath, they say this is not their speech, and here today they claim it is their speech. I don't think the court should take any of that, especially since just last term in Tamna, they represented that they had no idea that ISIS was even operating on their platforms. And it seems quite unusual to say that my friends on the other side are representing anything that's anything like an editor when they don't even know a terrorist group is on their site.
Well, I don't mean to bother you before, but you know, Elon Musk launched Twitter, and he seems to be perceived as having a different policy and being responsible for some of the stuff that's on Twitter, where other companies, Meta and so forth, have different views. And it seems just as a question of fact that people do attribute something on X to Elon Musk allowing it to be on X, whereas you know it's not allowed on Meta or something else like that. It just seems that your position seems to be contrary to just sort of the reality. And that's why I asked whether it's a question of law or fact. You're sort of suggesting if they disclaim it, it's a question of, is it, well, maybe you can give me some clarification.
Of course, Your Honor. So with respect to X and Elon Musk, there's of course a different style in which content moderation is applied there as on Facebook. And I think you'd be hard pressed to find two social media corporations that moderate content in exactly the same way. But the question before the court is whether this content moderation is expressive in any of these instances, regardless of the stylistic differences between how one company or another might choose to go about it. And I think what's very insightful here is that before Elon Musk took over X, back when it was Twitter, there was no message that could be discerned from how content was moderated on Twitter. And as Hurley and Miami Herald made clear, the message is the core part of what makes something expressive, because a observer can discern a message from what is supposed to be expressive. And as Twitter, there was no message that could be discerned by an observer from the content moderation. And again, as X, there's no message that can be discerned from the content moderation. And so as a result, Your Honor, was not expressive before and still is not expressive now because there's simply no message.
Well, you bring up Hurley. What message does one discern from a parade that one doesn't discern from what Judge Max just asked about how X is being run versus how Meta might be run?
So Your Honor, with Hurley, I think the message was a celebration of Irish American culture, and the particular message that the parade organizers in Hurley were getting at is, as part of this Irish culture, there were were the traditional Irish Catholic values, which included the position that marriage between a man and a woman, and other opposition to what the Irish American gay, lesbian, and bisexual group might have as their own message. And so it's certainly a broad message, and really makes clear that it need not be a narrow, particularized message, but there's still a message in advancing and supporting this Irish American culture and the traditions and values that it includes.
So why wouldn't Meta or X or one of the other platforms say, our message is what we define in the terms of usage, which is certain speech we don't like, we don't welcome here, and we don't just want to associate ourselves with that speech?
I think the issue here is that if my friends on the other side are able to define their message with such a broad level of generality, then I think Pruneyard would have had to come out the other way. I think Fair would have as well, because in Pruneyard, the mullet issue could have just represented its interest in having a certain kind of environment, which is the same kind of amorphous interest that respondents are asserting here. A message needs to be far more particularized, and I think what really helps address the issue here is that we have absolutely no front end selection here like we would with the newspaper example they're going to try to bring up in a few minutes. There's no front end selection here. For terms of section 230, they disclaim this is their speech. In their own terms of service, they disclaim this is their speech. This entire case is really just about holding these social media companies to their own word. The heart of this law is the non-discrimination provision, which simply says that their terms of service ought to be applied equally, as they hold themselves out to be.
Council, what about a platform such as Truth Social, which is clearly got a political angle to it? I mean, I don't think anybody would equate Truth Social with Facebook in terms of a message.
Yes, Your Honor, I think in cases such as Truth Social, there may be a message at issue, and it's possible that on an as-applied challenge in the future from a company such as Truth Social, this law might not survive this court scrutiny. However, today this case comes before the court on a facial challenge, so the question is not whether there is a conceivable case of a corporation such as Truth Social where the law might be invalid, but rather whether there is a plainly legitimate sweep for this law. And I think when we look at many of these social media platforms, platforms such as Twitter and Facebook, but even more so platforms such as Uber and Gmail, which fall within the scope of social media as defined by SB 7072. When we get to that issue, there's very clearly a plainly legitimate sweep for how this law could be applied. And so even though there may very well be some as applied hypotheticals in which the law would be invalid, at least on a facial level, it still must be constitutional.
So I just think that as this court made clear in IFLA, the First Amendment exists to create an open marketplace of ideas so that the truth will prevail. My friends on the other side like to cite NIFLA for their own propositions here. I think the exact opposite. NIFLA supports our proposition that states are not, the Constitution does not prevent states from defending the free exchange of ideas when there is absolutely no message at issue, like there wasn't in FAIR. In FAIR, this court said that empty classrooms do not speak. The same can be said here. If there's a user who is just no longer on one of these social media companies the next day, there's absolutely no clear message. And back to what we were talking about a little bit before with the transition from Twitter to X. Sure, the user experience did change, but there was no message that changed at all whatsoever. There were a gazillion different messages that a user could have intercepted in the interim. And for the reasons we've presented here today, we ask the court to reverse the 11th Circuit and allow Florida to continue on its quest to protect its consumers in the state of Florida.
Thank you. So you may proceed.
Mr. Chief Justice, and may it please the court. I'm Nathaniel Marks.
And I'm Edward Napoli, counsel for the respondent and choice.
Today's case asks you to decide whether Florida's social media law is in line with the First Amendment. It is not, because it violates the editorial discretion rights of social media companies compels unwanted speech, and discriminates against certain points of view. Petitioner's defense of the bill cannot hold up under strict scrutiny and is neither grounded in history nor in precedent.
Platforms largely speak not through their own content, but through content moderation activities on their sites. That content moderation is protected under the doctrine of editorial discretion established in Miami Herald and expanded to entities in control over private forums in Harlan. First Amendment protections apply not only if the speech originates from the moderator, but also if the speech being moderated is that of a third party, even if the resulting moderated speech does not have a particularized message.
The speech compelled by SB 7072 is unduly burdensome and is not purely factual or uncontroversial, in violation of the standards set by Zauber. SB 7072 requires that for each of the tens of thousands of content moderation actions taken each day, there must be provided an individualized explanation, and it further mandates that those explanations be thorough and precise, a task that is impossible to do because of the vagueness of the terms and because of the sheer vastness of content moderation decisions. It is a fundamental right to decide not just what to say, but also what not to say. And the decision to exclude certain messages from speech is just as protected as the decision to include other messages.
The purpose of SB 7072 has been repeated over and over again by the politicians responsible for its existence. That it is a law meant to target social media companies for perceived leftist leanings. Blatant viewpoint discrimination of that kind is impermissible, even if a law is spatially content neutral.
So where do you get the purpose? From discussion during the legislation's promulgation?
Well, Your Honor,
Did the governor start the process, or how do you get the purpose there that you're just saying what the purpose was?
Well, Your Honor, we looked at statements, including the signing statement of the bill, which in and of itself might not notion that it's unconstitutional. We also looked at the statements of other officials, such as the head of the state senate and the lieutenant governor and other officials outside of the signing statement context to basically determine what the motive was for passing this bill. So beyond that.
And what are the damning statements you find?
Well, the statements are generally that these platforms are overly leftist or that they are suppressing certain kinds of conservative speech. And that the goal of this bill is to open up the marketplace of ideas, but really only for certain speech that's preferable to the government of Florida.
You say it's only for certain speech. Why is that? I thought the non-discriminatory provision would have applied equally.
Well, Your Honor, it would apply equally, but the purpose of the law is not solely just to open it up to left-leaning speech or right-leaning speech, but rather for speech that the government of Florida feels is being suppressed on social media platforms.
In that case, if going back to the point Judge Max made before, if you have X being managed one way day one and managed a different way day two, and in day one you suppress one type of speech, and in day two you suppress a different kind of speech, wouldn't the law protect both types of suppressed speech?
It would, Your Honor, but that doesn't change the fundamental motive of the bill. Regardless of what its effects are, this court's precedent has been very clear that the purpose and the motive of the bill can make it invalid. If you look at O'Brien, it's clear that even though a bill can incidentally regulate speech, the motive for the regulation cannot be to suppress certain kinds of speech. If you look at Rosenberg.
Maybe the terms are a little unusual here, right? You use content moderation, which sometimes might be called censorship. If you're stopping somebody from speaking, it's different than prohibiting the stopping of somebody from speaking, isn't it?
Yes, Your Honor, we think that there is an important distinction here that this is a private entity in control of a private forum in the sense that social media companies are private businesses. We'd say that if the government tried to do something similar to this, it might be seen as censorship, which wouldn't be allowed, but because uniquely under precedent for cases such as Harlan, because it's a private entity in control over a private forum, it does have the editorial discretion in this case.
All right, so one of your clients includes Gmail, right? The company that owns the services that are provided under Gmail.
Yes, Your Honor, I believe they're part of the net choice.
Right. Would you take the position that Gmail can scan people's messages and then decide not to deliver the ones it doesn't like?
Well, Your Honor, we do think that Gmail can exercise editorial discretion over direct messages between people, yes.
But Your Honor, it's important to focus on really what is the meat of this case. Gmail has given no indication that it seeks to do that. Obviously, that would be disastrous for their business. What this bill is really targeted at are the organizations that are moderating content on their sites right now. Organizations like Reddit or Facebook or Twitter or X. These are the organizations that are being targeted by this bill. These are the ones that will be affected by it in actuality. It is true that organizations like Gmail or Uber could have editorial discretion that could be impacted by this bill. But the focus is right now on which organizations are actually exercising those rights.
Counsel, could you respond to what I think is the petitioner's main argument, which is that the social media companies seem to be wanting to have it both ways. They say, we're not responsible for this content. It's not our content. We're just hosting it. It's the customer's content, the user's content. But then at the same time saying, if you try to restrict our ability to censor that, you're affecting our message. And it seems like, I think it was their words that you're trying to have it both ways.
Your Honor, I think our friends on the other side are slightly mischaracterizing what we're trying to say. We're not saying that the content on these sites is all the platforms. Obviously, it's not. People are posting their own content to these sites. The speech interest here for the organizations, for social media platforms, is not the content itself, but rather the actions. These content moderation decisions are actions that are imbued with speech. It's not so much that the speech on the sites is the platforms. That's what we said in TAMNA, and that's what we're saying now. But rather, it's the actions that are taken, the prioritization of certain speech, the removal of certain speech. That is what we would wish to see protected, and that's what we would say that SB 7072 is limiting in a very severe manner.
Counsel, suppose somebody puts libelous speech up and you don't moderate it, or a copyright violation and you don't moderate it. You have the choice of doing it. Maybe you exclude some libelous speech or some copyright violation, but you don't exclude others. Are you responsible then, since you have the choice to do this, and you said it's your decision of what to moderate, what not to moderate?
Your Honor, I think Section 230 is clear that these social media platforms aren't to be held responsible in direct ways for the content that they have on there. Libelous content on social media sites. Again, it's not the content of social media.
Well, I'm not saying that you're being held responsible for the content itself, but you're being held responsible for your editorial decision to exclude some of it, but not exclude others. And suppose you consciously decide, we're not gonna have Taylor Swift copyright violations, but we will have, Beyonce copyright violation. Or we allow you to slander, a particular person, but not another person. You're saying that you're making an expressive choice by deciding how you're gonna moderate, but then you're saying you're not responsible for your choice.
Well, Your Honor, I think that there is a distinction that we can make between Section 230 liability protections that social media companies have enjoyed. And then separately, there is this editorial discretion that they do have over the content they moderated that is ensured via precedents such as Harlan, where they can rehash that content. It's their own speech. So we think that this is a unique scenario where they are given this liability protection. And this isn't necessarily a scenario for many other industries, but they do enjoy this special protection. And that's what enables them to basically.
Well, even apart from Section 230, I understand that your user agreements basically give you the same protection, that you basically say, if you're using our site, know that we're not responsible for anything. And again, I just get to the question, can you have any liability for your moderation decisions?
Your Honor, if somehow the moderation decisions themselves were libelous or slanderous in some way, which I don't see how that necessarily could be possible. But if the moderation decisions themselves were somehow tortious or had some of their fault, then it's true that platforms could be held liable for those because those actions are our speech. But the speech of others on these sites, regardless of what a platform does to it or decides not to do to it, that still remains the speech of the user who posted it, regardless of what the decision is of the platform to do with it. Can
we talk briefly about this Outerberg case, where I realize it might be very administratively difficult to give a justification for everything that's being censored, but ordinarily, we wouldn't expect this to be a problem, that when businesses interact with others, we regulate it as business speech. And you know, if suppose we said to Amazon, if you refuse to take a package back, you have to give an explanation for why you refuse to take the product back. Somebody says it's broken or delivered late, and they say we reject your claim, and maybe a legislature passes a law saying, hey, anytime you reject a claim, you have to give a concise, prompt reason for doing that. Why isn't this just regulation of business speech?
Your Honor, it's really part of it's one of the two reasons is there's the volume of content moderation decisions, and then there's also the vagueness of the term. So there are tens of thousands of these actions being taken every day by all kinds of different platforms. They're moderating videos, they're moderating text, they're moderating all kinds of things to the tune of tens of thousands. And the bill requires that an individualized explanation be given for each single action. So for every action, tens of thousands a day, in order to have the explanation be precise and thorough, whatever that may mean, that requires a very intensive effort. And the terms that this bill uses to describe what those explanations must be, which is precise and thorough, those are hard to meet because by themselves, they don't really mean very much.
I'm just struggling to see an example of where you would have enough information to decide to ban a tweet or ban a posting, and yet not have enough information to give a reason for doing it. But you simply say, well, these words triggered a violation of this content rule.
Yeah.
Well, Your Honor, we think that because of the exact wording in SB 7072, they do have to be individualized explanations. So there is probably some level of almost a cookie cutter formula that you could follow, but then there is also a mandated individualization in that too. And there is some ambiguity regarding that because the law was never actually put into effect. So the answer could be primarily that we don't know the full extent, and this could end up creating a huge liability.
Could we go back to that? Why was the law not put into effect? Isn't that because you sued?
Yes, Your Honor. I think it was enjoined by the district court.
Right, at your request.
I'm sorry.
At your request.
Yes, sir.
Okay, and this is an applied, a facial challenge.
Yes, Your Honor.
And what's the standard for that?
Your Honor, it requires that the bill not have a plainly legitimate sweep, which we say that it does not have a plainly legitimate sweep.
Right, and your friends on the other side say it does, and all these factual questions that we've been debating this morning could be better addressed on an as applied challenge. What's your response to that?
Your Honor, I think that regardless of whether or not there is some factual information that would be helpful, there's a lot of legal questions that can be decided right now. It doesn't take an intensive factual analysis to realize that an individualized explanation for tens of thousands of moderation actions a day is unduly burdensome. And the precedent in this court is controlling in this case, which is that these companies have editorial discretion rights that would be violated if this law were to come into effect.
But so is there a distinction between a newspaper that chooses what editorials to publish and your clients?
Your Honor, we do not think that there's a distinction from editorial discretion. We think that that precedent has been applied first and early to other venues other than, say, newspapers, and it certainly applies here to social media companies.
And going back to Judge Maggs' point, if you know enough to tell somebody we will stop your speech, why isn't that enough? You know enough to give that person an explanation for why you did decide to stop their speech. When you come back with, well, but there's thousands of these moderation decisions, well, whose issue is that?
Your Honor, I don't think that Florida should be able to limit the amount of speech that these companies have just by putting on this burden of speaking. Because what the disclosure requirements are really is putting a burden on speaking. If you choose to speak, then you will have to jump through all these hoops in order for it to be legal. And the issue with that is it's an unduly burdensome thing to do. But also, this court has never held that, that your First Amendment rights are conditioned on you doing what the government asks you to do. So I think that while it's true that they could just limit their content moderation actions, that would run contrary to this court's precedent about the person.
Anything further?
No, Your Honor, we've run out of time.
Thank you.
Thank you.
Well,
Your Honor, I'd like to begin with the platform's point on Gmail as a common carrier. So as this comes on a facial challenge, the question before the court today is whether there is a plainly legitimate sweep to SB 7072. And my friends on the other side have argued that no social media platform, not even something such as Gmail or Uber, both of which fall within the scope of SB 7072, can have this constitutionally enforced against them. Now, regardless of what this court believes in terms of whether the common carrier analogy is apt with companies such as Facebook or Twitter, I think Gmail is a very clear case, and there are many other social media companies just like it where the common carrier analogy fits perfectly. If we look at the Telegraph as sort of a point of comparison, this court's precedents make clear that the Telegraph is a common carrier. And it has no right to listen to your messages and decide, I don't like what your person A is saying to person B, so I'm just going to censor that message. And that this is well established in this court's line of precedence under, I believe, Harlan Communications. So with that in mind, the function of Gmail is not all that different from a modern day Telegram. You write your message and you send it through the service and it arrives at the recipient as you sent it. There's no compilation of messages in a certain way as might occur on social media. And with that in mind, it's almost exactly akin to a modern telegraph. So
There are differences though, and I don't know if this is still the same policy, but at one point Gmail was reading your emails for purpose of advertising. And you agreed to that, and that was the business model. You got this free thing called email that was widely accepted. But you realized you were going to get some advertisements that were going to be targeted to you based on the fact that they were looking at the email. And it seems a little different from Telegraph, where you're just paying by the word or by the character for the Telegram, where the whole idea is we're giving you this for free, but in the process, we're going to look at what you do.
So, Your Honor, well, there's definitely some difference in how Gmail versus a Telegraph might operate. The Telegraph collects its revenue directly, and Gmail collects its revenue by selling information to third parties. The concept or the way the message is being transmitted from one speaker to another to a listener is much the same. And I don't think the way in which the company draws its revenue from facilitating this communication really affects the First Amendment issue here.
I also think that any idea that advertisers should get heckler's veto on the First Amendment is purely at odds with this court's case law. And adding on to the telegraph analogy or the common carrier analogy more broadly, Verizon can't cancel one phone call if you're just talking to your friend. And it would seem silly to say they could cancel just a group conference call if that would be any different. So I think the common carrier analogy, while I'll admit is not perfect, fits this case well enough, especially with the backdrop of Section 230, where these social media companies hold themselves out to have no stake in the content on their platforms at all. That's what gives them immunity in those instances. But then here they speak out of the other side of their mouth. And for Section 230 purposes, the Florida law has explicit carve-outs for good faith exemptions to Section 230. So really what respondents are arguing for this court here is to give them a right to bad faith content moderate. And I don't think the court should indulge that either.
Counsel, in your remaining time, could you address the respondent's point that it's totally unrealistic to give tens of thousands of specific reasons for content moderation decisions every day, as this bill would require, that this is grossly different from what was at issue in the mere factual information at issue in Zauer?
Of course, Your Honor. So as Your Honor pointed out in respondent's argument, these platforms have enough information before them to make their content moderation decision one way or another. There's is some sort of factual basis behind every content moderation choice these platforms make, and there's at some level some review there. And with that in mind, the platforms surely know why they are. I apologize, I'm nearly out of time. May I?
You may continue, but if I may, with fourth indulgence, when we run a trial and there's objections to evidence, the trial judge just rules. And the trial judge doesn't write an opinion. And my gosh, we would never get through a trial if every issue of relevance or hearsay or whether this was in the scope of the direct examination, we had to write an opinion in order to justify that decision. I mean, I think we can recognize that a decision can be made without necessarily having but it would be a much greater step to have to write an opinion explaining each decision.
In terms of the much greater step, I think it's important to note that these companies, as represented by respondents, they signed on to the Santa Clara Principles just a few years ago, which outlined a very similar thing in terms of disclosures of Florida law. They're also behemoth companies, and they're totally compliant with similar provisions at issue in the EU. So I don't think there's any real question about feasibility here. While there are still questions in the record about what disclosures my friends have made and in the status quo and what will have to change in the future, I think the record is unclear on that point, solely because of how my friends have chosen to litigate this case. For those reasons, I don't think the court should strike down Florida's law under its outer.
Thank you very much, counsel.
Case is submitted. Everyone can just go outside for a few minutes and the judges can deliberate. And we'll let you know when it comes back. Judge Blanford, want to call the case?
Yes. All right, in the case of Moody versus Net Choice, the court has heard superb arguments by counsel this morning. On behalf of the judges of the court, we're tasked with, justices of the court were tasked with picking the best advocates team and the best advocate. First, I want to say on behalf of all the justices that it was an incredible competition. All of us are sitting judges. I sit as a district judge here in the district court in DC. I'm particularly sitting on all these January 6th prosecutions in DC, so I'm seeing a lot of often young defendants who have been misguided, and I find misguided in their, some very civic minded, but misguided on a particular day and a particular time. It's refreshing to see young people today doing what I saw today. You're on your path to being lawyers better than most of the lawyers I see every day, and making arguments that are incredible. For somebody in high school, I couldn't have done what you just did when I was in high school, I guarantee you. I think you did a fantastic job, all four of you. And I marvel when I have come over here in prior years and this year as well, that high school students performing at the level all four of you did here today. So I commend all of you. After a vote among all of us, we have picked the winning team of lawyers today would be the petitioner's team, Kevin and Maxwell. And we have picked this, the outstanding advocate, Kevin. So congratulations to both of y'all. I do not take away, however, from both Nathaniel and Edward, who did an outstanding job as well. I think that all three of us will make some comments, as well as Professor Blackman, about how well all of you did. We were all impressed that high school graduates, high school students, your sophomores, your seniors, but high school students could have that level of advocacy in very complicated First Amendment questions. I deal with First Amendment every day, and what I've been doing since January 6th And I do know something about this, the First Amendment these days. I write on it frequently these days. So I'm speaking on it sometimes now and pilloried by some and spoken endearly by others and threatened with my life by others. So I know a lot about First Amendment these days. These are difficult questions, and what you face today are difficult questions. I do commend all of you for really outstanding advocacy. I see lawyers that put me to sleep every day. None of you put me to sleep. I commend all of you for really outstanding jobs, but Judge Maggs had some comments first, and we'll be glad to entertain questions too, but Judge Maggs.
Well, first, I'd like to repeat everything Judge Lambert has said. Just an excellent performance by all four of you, and you should be very proud of where you are. I also think that the case was a brilliant selection because it had something for everybody to argue about, and it really showcased your talents. One thing that you might not gather from a moot court competition is that, you know, in a moot court competition, the judges are kind of there to push you and give you a hard time and see how well you respond. In a real case, we have so little time for oral argument that we try to use that time to ask questions about the briefs. And we ask the questions not to participate in the argument, but instead to get information that we don't have. There's no other easy way to get it. I've just read your brief and I've got some questions and I want to know the answer. And the worst thing you can do in a real argument is change the subject. You know, it's a common tactic in arguments. When things start going rough, you change the subject. But if the judge has asked you that question, you really ought to answer it. And that's one of the things I thought all four of you did really well at. I didn't see one instance of, well, I don't really want to talk about that. I want to talk about something else. I think you were very good at addressing the main thrust of your opponent's arguments when you were confronted with them. And I think if you think back to this argument and think about how each of you did that, that would be a good guide for you in the future. That when a judge asks you a question, it's because they want to know the answer, and you give them the best answer you've got, but you don't change the subject.
I think, I like everything that's been said, and my comments are gonna be to the team that was the respondent, so you didn't win. But that's not because you didn't do a great job. We had to pick a team, right? That's the way of the competition. If we could have awarded trophies to everybody, we would have, because you guys did a fabulous job with the arguments that you had. You engaged with the other side, and that is like just the other judges have said. It's really important. These competitions are competitions. You gotta pick somebody, but it would not mean that that wasn't because you all didn't do a superb job in presenting your position and knowing your case well and knowing your facts well and getting the strongest argument that you could for the positions, even with what might have appeared like hostile questioning. I was pushing you on purpose, but that's you did great at that.
Thank you. So I've been running this competition now for more than a decade. These are two of the more evenly matched teams that I can recall seeing. And within each team, both members are evenly matched. What often happens is on a team, there's one superstar and another one who is kind of just the caboose, kind of following along. And I think with both teams, you were evenly matched, both Kevin and Maxwell. I mean, I think in the respondent in particular, you're sophomores. I can't get over that. You guys are just, like a couple years out of middle school. So it's just, no, it's remarkable. I had breakfast with them this morning. They listened to Supreme Court arguments for fun, and then, while most kids are just, scrolling in TikTok. So it truly is remarkable. So I think both teams were competitively pretty evenly matched. This is actually a hard one to pick the winner. Usually it's clear who the winner is. This one, I don't think it was so clear the winner was. And within each team, 1-2, 1-2, you're at parity. And even though the two of you had never met before today, which is sort of stunning, you had a very natural rapport among the two of you. And I think the two of you also have a very good rapport, where you sort of hand off very naturally. And at one point, one's in a little trouble, you kind of bail, and the other one you kind of help in, you swoop in, which is good. When you get up into law school, it's solo, like one at a time. But at least the high school competition like this. You have a grasp of the case law that is advanced. What's the standard for facial challenge? That's not an obvious thing. I mean, that's hard. You know, you're making policy arguments. You can't possibly run, you know, explanations for every single person who has a takedown notice, right? You know, you bring up Sedona principles and the European Union, and you're sort of going into things that are just not obviously in the record. You're distinguishing Gmail. Etsy didn't come up. I guess there are no Justice Barrett, no craft people at the table. But the Gmail example was very good for both sides. So there was a lot of very strong advocacy here. And I want to just echo what Judge Lambert said. I mean, if you just Google the guy, he's been under the gun a little bit recently. He's got a number of defendants being sentenced on January 6 issues. And there was a piece in the Wall Street Journal about this a few weeks ago. And I think one point that Judge Lambert makes is you have these young people who made decisions that were not good decisions. And you're right, they were civic minded. They thought they were, you know, trying to save their country, trying to save the Constitution, whatever else explanations they sort of bring forward. And you know, in the process, they destroyed government property, they trespassed, they assaulted federal officers and so on. And then you see that, which is only about 3 blocks that way. And then I come and do this competition, like, well, you know, but there's a lot of hope. There are brilliant young men and women who are 16, 17, 18 years old who are thinking about the Constitution profoundly and who are reading Supreme Court oral arguments and are writing briefs and standing up on their 2 feet and making arguments for the First Amendment. You know, the two of you are in trial, you'll be opponents, but you're friends as soon as you get off the bench. And it really gives me a reward. I do this primarily for my own gratification, that there is hope for the future, and I believe that I am confident that in 5 or 6 years, you guys will be in law school. I'll see you in court competition. You guys maybe 7 or 8 years from now, you'll be in law school at a moot court competition, and you know, maybe you'll be clerking one day in one of the courts here in DC. There are a lot of good courts in DC, not just the big one, a lot of really important courts in DC. And it just brings me so much satisfaction to see you thrive. Also, you know, I thank the parents and the coaches and the teachers. These students aren't here by chance. They didn't just sort of wake up one day and decide to have a competition. A lot of work goes into it. But those are all the comments that I have. You can ask us questions too. This is a 2-way street. It's not just, you know, one way. I'm happy to answer any of your questions about the court, about the competition, about the judge, whatever else you want to ask.
Let's start with Kevin.
All right. I suppose, Judge, my question would be, what sort of advice would you have for me going into university next year and onto law school to sort of get a good footing in the legal field and start my career? Well,
I say to kids, you know, first you gotta make good grades, and kids don't like to hear that, but you know, the one thing we always look at is we start with grades and then you go from there. What else do they do? Grades are a measure of success in life, whether you like it or not. So you start with good grades, you go from there. You go to law school, I was vice chairman of the moot court board. I like moot court. I think moot court is a big deal. In my law school, I went to the University of Texas. I undergrad and law school. In my law school, they had an appellate seminar. I got to take one case to the Court of Appeals and argue in the Fifth Circuit, an appointed case for a criminal defendant. I got to fly to New Orleans, argued in law school as a student. Obviously, I lost, but it was a great experience in law school to argue a case in the Fifth Circuit. I had a terrific time in law school. It was, I graduated from law school at a bad time. I graduated in '67. I was drafted. I knew I was gonna go to Vietnam. I went to Vietnam. I wanted to just submit to the draft because you could go in for 2 years if you went as a draftee. If you went in JAG, you had to go to 4 years. 4 years seemed like forever. I didn't want to do that. But once I got in the Army and was in the draft, I thought the Army would make me, it would be logical to make me a legal clerk. They put me in advanced infantry training. Suddenly, they're going to send me to the infantry in Vietnam. So I went to JAG after all. It turned out I had good experience at JAG. I couldn't believe it. And I ended up going to JAG and going to Vietnam, but I went to JAG, so I lived. Came back to Washington from Vietnam and ended up staying here, so. Had a different career than I ever envisioned when I was in Texas, but I ended up loving Washington State here, so. Once I stepped down, I stayed, here, but I go back to, once I stepped down as chief judge, I go back to San Antonio for 3 months, sit as a visiting judge, so I've got the best of all worlds now. I spend the winter in San Antonio and I just do trials 3 months. We had too many January 6th cases this year, I couldn't go back, but I hope next year settle down and we'll go back, but. In looking at you when you graduate from law school, I'm gonna look at your grades, I'm gonna look at whether you made law review, I'm gonna look if you got a leadership position on law review, because that means your peers liked you, they elected you an editor-in-chief or something like that. That's success ultimately. Law review clerks, clerkships are important. Clerkships are good to be a lawyer ultimately, that's my advice. Success in law school, success in college comes with hard work. That's part of life. Y'all have done hard work to get here today. You already know that. You can, it's obvious from seeing y'all today. Anyway, that's a long answer to your question.
Thank you, Judge.
Y'all want to start a question too?
I had a question for Judge Toro. I've tried searching it up online and I've looked at the website, but I'm still kind of unclear as to what is the jurisdiction of the tax court and what the cases are.
So, tax court is an Article 1 court. And what we hear are controversies between taxpayers and the Internal Revenue Service. And we're quite unique but close to it around the country because we have jurisdiction over the entire United States. So our court gets to hear cases in 74 different cities. It includes New York City. I just came back last week. I was in New York
So
City.
y'all fly out all kinds of places.
We do, right? And Minnesota is another one. We sit in St. Paul. So the types of cases, think of it this way. Your parents, probably you have to file your own tax returns, but your parents file tax returns. And if the government comes and says, you didn't do that right, we think you owe us more money than you have shown on your tax return. You have a couple of options. You can pay it and go to Judge Bailiff Court and sue for a refund. You'd get a jury trial if you wanted one. That'd be the one path. But the key piece was you have to pay it first. A lot of people either don't want to pay it first or don't have the money to pay it first. If you don't want to pay it first, you come to our court. $60 gets you into our court, and then you get a judge to decide whether the government was right or not in saying that you owed more money. And at the end part of that, the result gets appealed the same way, whether it's mine or the district courts. It goes to a court of appeals, but while the District of Columbia District Court judges have one boss, the Court of Appeals at the DC Circuit, I get 12 bosses because depending on where you live, the taxpayer lives, my case can go in any of the 12 regional circuits and then eventually get to the Supreme Court. So that's a lot of fun. And since you asked and since I bragged about my court, another fun, very fun part of the job is that we're a very collegial court, but Congress also, because it's a national court, was concerned about uniform application of precedent. So we have an internal statutory process where, unlike district court judges who just make a decision and then you take an appeal, they don't talk to other district, or they don't need to agree with other district court judges. Each district court makes its own decision. In our court, I get my decision done and then my chief judge reviews it. They agree with it, on it goes, but then the full court, and there are right now, we're authorized to have 19 judges. All of us sometimes, for important cases, get together and vote on them. So I get to do both trial work and to some degree, you can think of it as appellate advocacy because I got to convince other people to go along with me if I want my view to.
How often does it go to the full 19?
I'd say we have 8-ish, yeah, 5 to 8 cases a year, depends on the year.
The super on bond, that's a lot
Right.
of judges.
Right, we meet every month and then we don't have a case every month, but sometimes we do and sometimes we have more than one case. And not infrequently they are uniform, I mean, they're unanimous, so there isn't a dissent. Because sometimes if it's a procedural issue of first impression, for example, I had a case like that where new issue of first impression, we were saying the statute means this, but it's good to know if everybody agrees that the statute means that, because everybody will get that case later. So instead of coming later and saying, oh, but we forgot to do this and that, the other thing, we say to everybody.
I'm sorry, I'm asking questions, sorry, I can't, but, what are the questions our students have?
One question I've been interested in, and this is just with a research project I'm working on at present, but I've been sort of curious as to the relationship of the English common law and English law of equity sort of merging into the United States Article 3 courts. I guess how does that sort of play out from a judge's perspective, in as much as you have to take these two very different and historically separated traditions of bodies of law and sort of apply that sometimes as one.
Not very often. You know, as a district judge, we're usually looking at most of the times, there's, you know, you're first gonna look at prior cases, you're gonna look, in my case, I'm gonna look at if there's a DC Circuit case on point. If there's not a DC Circuit case, we'll look at other circuits. If I find other circuit law that's controlling, then I'm gonna decide. If it's a Ninth Circuit, I don't wanna do that because the Supreme Court is probably gonna reverse it. So,
Or the Fifth Circuit nowadays, don't
Fifth Circuit now,
I love the Fifth Circuit.
the Fifth Circuit loves me. In all my cases I've sat on in Texas, I've been going down there several years now. I've never yet been reversed by the Fifth Circuit. I could get reversed 3 times in a day in the DC. The Fifth Circuit has never reversed me, so I kind of like the Fifth, but I also know their track record is going downhill quickly in the Supreme Court, so. But, you know, on a commercial question, we don't get a lot of those in DC, but if it's a commercial issue, there's a lot of times there won't be a DC Circuit opinion, so I'm just looking what the Second Circuit did. If it's some other kind of issue, you know, I like the Third Circuit, a lot of times the Third Circuit is pretty nonpartisan, so you look at other circuit law. You can look at another district court opinion, but I mean, they have the same weight as mine, so it doesn't really mean a whole lot. A lot of people, when I first became a judge, people started signing me to myself, and I said, don't you have anything better? I mean, signing me to myself doesn't mean a lot, but lawyers think that's good, to sign me to myself, but I know I should be consistent with myself, but I'm looking for law, you know, not just me.
Any questions for the coaches or the teachers or parents who else want to ask?
Oh, well, I have questions. I'm just wondering which way you think this decision will go, like with the actual Supreme Court, this case.
Well, my law clerks and I sat and listened to first the argument shortly before that of the case in which my court is being heard on one of the January 6 cases. And then my law clerks and I all listened to the argument in the Trump case. My prediction before they met was that it'd be reverse remand, and they would tell the lower court to my court to we need to figure out just what are the presidential acts that were official duties and which weren't, and I think that's still what's likely to happen, so. But I don't say that out loud because I don't get quoted on what I think they're gonna do, but I think it's possible the district court could still do that and still get it done before the election, but I don't know, it depends on how much guidance 5 justices can give about how to decide what is official action and what's not official action. To actually be able to write that decision and then get a jury selected and get it to trial. About what are official acts and what are not official acts. There's no prior actual holding in the criminal context of what official immunity the president has, but clearly the president is gonna be immune for some actions that he takes as president, and I think that it was hard to count the votes exactly where the 5 are for that. I personally thought in listening to the argument that it was an example of the Supreme Court at its best of really being fully engaged and really, like the argument here today, a really good substantive argument. I was a little shocked at the public reaction that there was a lot of the public that thought that they were Trump stooges, they were just gonna vote Trump's way because they've been appointed as conservative judges, and I don't look at judges by what president appointed them, even though I get labeled with that all the time. Because I'm a Republican appointee, but I don't look at that as what I'm doing as a judge at all, and I resent that labeling of me, but I think it's not healthy to look at the Supreme Court that way. They've been appointed for life. They're trying to do the best job they can. They're trying to figure out, some of them come to it because they worked in presidential administrations frequently at the White House. So they have a different view of the role of the president than even I might have. And you have to understand that doesn't mean what some of the press attributes to them, that they're Trump clones or something like that. They're not doing it because they're Trump clones. They have a view of the presidency that may be different than even I would have. I don't think the president is a king. A couple of justices said that. I agree with them, but I probably, one of the cases I got reversed on early on when I struck down Hillary Clinton's
Task force.
Medicare task force, and said President Clinton didn't have the power to appoint that task force and make it non-public. The Court of Appeals reversed me, in very public reversal of me, and said she's the functional equivalent of a government employee, so that statute didn't apply. And to me, the Court of Appeals just rewrote the statute to say she's the functional equivalent of government employee, which she wasn't a government employee, and therefore the meetings she was having should have been open to the public under the Open Government Act. So I struck down her ability to have these private meetings in setting up the Medicare Act. And very visibly, front page headlines, New York Times, Washington Post, I'm reversed. I'm totally wrong in my interpretation of the law.
That's right.
Should have been open. And my interpretation of the law was dead right, but the Court of Appeals said she's the functional equivalent of a government employee. What BS is that? But the presidentialist who wrote the opinion for the Court of Appeals was a presidentialist. And there are judges who are presidentialists. Now, there may be justices who are presidentialist. I say that to you, so I'm a little concerned about what the Supreme Court's gonna do. But they're doing it not because they love Trump. I mean, there are presidentialists there, so but you can be a presidentialist and not be a Trump lover.
Just to follow up on Judge Lambert's comments, when you're a trial judge, and I had been a trial judge in the Army before
For a long time.
and I often talk to the new trial judges, and I talk about being reversed by a court that's higher, and I say, well, there's really 3 possibilities. One is, it's just a difference of opinion. I mean, you should have decided, you gave your view, the appellate court gives their view, and it's the system. The system is that there are more of those judges and they decide. Another possibility is
They're wrong.
that they're wrong, you're right. That happens, and I mentioned that, I'm often in dissent, but I think I'm right. A third possibility is you are wrong, and they just corrected it, in which case you should say, well, thank goodness for that. So, it's a system that works, and as long as everybody understands their roles, that's how we move along, so.
Very good. Anything else?
I have to say on the Trump question that was argued, I think it takes some care to decide what the power of the president really ought to be. I mean, there's some complicated questions. When you look at the drone question, can the president order by drone killing someone? I mean, no court has ever had to rule on that kind of a question. I mean, there are some difficult questions. Should the courts decide, can the president do that? Is that a question for the courts to decide? You know, there's some difficult questions. It's not easy for the courts to even decide what our role is in that question. So that's a tough question, yes.
Could the judges identify 2 or 3 books that were seminal influences on you in terms of inspiring you to become lawyers? I'm less interested in sort of legal doctrine, but just sort of stories of judges or Clarence Darrow, great advocates, you know, that would be on a reading list for young people aspiring to be lawyers.
I couldn't hear the first one.
Books.
Seminal books
that
that
are
have written
law
law.
related, that are either stories of judges or, you know, famous advocates like Clarence Darrow or like.
I got one. You can read My Grandfather's Son. It's my former boss, and it's an excellent book about a sitting Supreme Court justice who has a story and a compelling American story.
I read that in law school. It's a stunning book.
And then Justice Scalia's matter of interpretation is what it's old. And I wouldn't suggest, you know, reading law, that's a much longer book, but a matter of interpretation is a very good, succinct introduction to how one might read law.
I've read both matter of interpretation and reading law.
Good for you.
Reading law is definitely a longer work, but there's a lot of good stuff.
I have to think about that before I answer that one. I haven't thought about that for high school.
You know, I always found that I got more out of reading biographies than reading just books about jurisprudence. And you can work your way through them, and in law school you will, but I think one book I really recommend is a biography of John Marshall, written by John Smith. And I think John spelled French by Jean. And I don't remember the exact middle initial or whatever, I know it's complicated, but it is a fantastic book about all the legal aspects. I think he really got the issues that John Marshall had to deal with, and it was kind of inspirational. It's just a fantastic biography. But there's lots of biographies. There's a good biography of Oliver Wendell Holmes, Yankee from Olympus.
Yeah.
I found that one to be really good. So I do like these biographical books. There's a collection of Justice Scalia's speeches. Was it Scalia Speaks? Yeah,
Scalia,
edited
yeah.
by his son and by Ed Whalen. And I thought those, if you're interested in, you know, what are the kinds of things that these people are concerned with and arguing about at the Supreme Court, it's a very easy book to read. And I think Justice Scalia is a good example of somebody who makes his points very clearly. You can agree with them or not agree with them, but you're not gonna understand them.
Yeah, it's a very good book on writing as well.
Scalia is readable because he's so fun. I should say, John Roberts and I were very close when he was nominated to be Chief Justice, and I helped him with his hearings when he was going through his hearings. And once I worked with him every night when he came back from his hearings and talked to him through his hearings, and I thought he was brilliant during his hearings. And when he became chief, he read the autobiography of John Marshall, the biography of John Marshall, and asked me to read it. And then he said, let's talk about what I should do as Chief Justice, how I should be a good Chief Justice. And he read it and I read it, and we talked about it at some length when he first became chief. And it is really good. I mean, it's an excellent book, and it's really good. When we started talking about it when he first became chief, we're still very good friends, but it is an excellent introduction to what it is to be a chief justice as Marshall was and Marshall's life and career and so on. So that probably would be the best advice I would have. He follows it, and he still believes in it.
He does.
Chief Justice Rehnquist wrote a book too, which is really geared towards high school students. It's called Supreme Court, How It Was, How It Is. And it referred to how it was when he was a law clerk for Justice Jackson, and then how it was when he became a Supreme Court Justice. And I think it's really geared at people your age and thinking about going into law.
One of the last conversations I had with Chief Justice Rehnquist when he was knew that he was terminal was I was convinced that Roberts was going to be his replacement. Roberts had clerked for him, and I told him I was convinced that Roberts would get his seat. He wasn't as convinced as I was, but I was sure it was going to be.
Who do you think
Roberts.
was gonna be?
Roberts had been nominated then for Senator Dale Connor's seat, but Rehnquist died and Roberts was renominated for his seat.
Who did Rehnquist think it was gonna be if it wasn't Roberts?
There were some other advocates at the time
Oh.
that he, but all the justices thought Roberts was the best advocate at the time, all the justices.
He was.
were, you know,
He still is.
yeah.
Could you talk a little bit about where you see the courts in general in the arc of American history? So
Well-
for these kids, they were 3 to 5 and, you know, sort of when the Tea Party came to fore and they were still in grade school when Trump was first elected. So one of the conversations we frequently have in our home
Well,
is this is the moment in
Yeah.
time, right? How does it fit in the big picture?
yeah, I think the courts are still we're probably at a critical point now because we're so controversial now. But we've always had controversy involving the Supreme Court in particular. I don't know how the current controversy will result. I'm disappointed in some things I read about the court these days. And concerned, that's why I decided to speak more publicly about some of the things that were being said that I thought were unwarranted. And I'm under some criticism myself. I had agreed back in January to do a speech I'm doing Wednesday in public that I'm probably gonna regret. So I'm doing an ABA open public speech Wednesday that is gonna give me a lot of criticism. But I had obligated to speak, and now I have to have Marshall's take me to the speech because it's gonna be in public. So, but I'm gonna repeat publicly what I've been saying, so. Anyway,
I'll just give you just a brief lesson. Saying what's unpopular is not ever easy, even with life tenure. You will not have life tenure for at least a long time, maybe you will at some point. And there are things that you might want to say and do that might alienate your friends and colleagues and peers. And there's a cost to doing that, and Judge Lamberth is living proof of that. So if you take nothing else from my dear friend's record, it's recognize that no matter what stage you are in your life, that sometimes taking a tough position is worth it. And often doing the right thing will not make you friends anywhere. And it's a good lesson that it's hard to tell a 16 or 17-year-old to do because you just haven't really you've done a lot, but you haven't really established yourself. But the more established you are, the more friends you have, the less you want to sort of take off your friends. And anyway, it's not a pleasant thing to do, but yeah, he needs a marshal service to escort him around. Thankfully, I think he's safe here and he's okay. I hope.
it's not healthy what's going on today, and but my path is clear of what I think is going on today, so I'm not troubled. My wife is a little troubled and is telling me what she thinks I should be doing, just laying low.
But what a senior judge means is he basically doesn't have to do anything anymore. He could just do nothing and his salary would remain unchanged. So the fact that senior judges continue to do service to hear these difficult criminal sentencing and criminal trials, I think it's a testament to a lifelong of service to the nation. And he's working for free at this point. The taxpayers are paying his salary no matter what he does.
I do love coming to these moot courts. I love seeing and I'm enthusiastic about seeing young people like you who are willing to think about going to law school, thinking about being lawyers. I can almost remember those days from high school. I admire what y'all are doing. I admire what you did here today. It was very admirable to see it. There's hope for our future.
As a mother, I want to thank the justices and Josh for providing the opportunity to these young men and women that were in the competition, but being able to be advanced in your careers and realize that the young people have a place and that they have a voice and that they have a direction. Too many in our society diminish the high schoolers who haven't achieved the CV long enough. And these 4 students clearly showed their CV is rich and what's in them is promising.
It's very good to see for the good of our country.
Indeed.
All right,
So we want to shake your hands before.
yeah, let's do the handshake, come up, and then we'll take some pictures. And then we can all get to the court and get some lunch to plan.
Where's your, right here?
Yeah. Please. In the Court of Appeals of the Fourth Circuit in Richmond, that's a tradition, after the argument, they always come down and shake hands. That's a nice tradition, I like that. You can go before? No.
No, I've not argued before.
No, where'd you first in the circuit for?
DC Circuit.
You were the
Judge Henderson.
Oh, that's right, Judge Henderson, okay.
Well, I'm aware of the tradition.
So Judge Henderson's very traditional.
Yes, she is.
Shake hands. We'll take a bunch of congratulations.
Thank you. Move this to the side so we can. I'll get over here and those. Judge, put the other two.
We'll do those in a bit. It's a handshake first. Nice to meet you.
Congratulations.
Can I ask one of the parents to take it on my phone if you don't mind? Whoever is competent to take it is fine.
Thank you, Judge.
Thank you.
Thank you very much, Judge.
You want to get the students sort of
All right,
papers first as
Let's
opposed
let
to.
you guys
Yeah,
out. Max,
outside,
have a
yeah.
over here.
Stand.
Right.
One, every other.
All right, yeah, switch with me.
Okay, that's good.
That's good.
Okay, how about 2 teammates together there?
Okay. All right, so we're looking at that black camera with the blue shirt. Good. All right, so just the 2 winning, the petitioner teams, so we'll do the respondents in a moment. Okay. Good.
Right. Great.
Okay, and if the 2 respondents come back, please. I'll circulate these pictures all later.
Great.
Okay, and you can now take a look at mommy, daddy pictures. Thank you so much. I think we are adjourned. This was so good. Thank you so much, sir. We'll catch me to great. Thank you so much, everybody. All right, Judge. Don't do anything I wouldn't do on Wednesday, which is not telling you much. I miss people all the time. It doesn't even matter.
Well, it's a panel, so.
Who's on the panel?
Andrew.
Thank you.
Definitely get me involved.
Iceberg, you and him on the same. Oh, man, that's gonna be. Where's it gonna be?
Yeah,
You never thought this would be the last year you've heard, did you?
Oh, great.
Yeah. Okay, it's kind of like, well.
I want to say, Judge, that as a physician, I'm very glad you ruled the way you did on Medicare.
Well, it's outrageous what they were doing.
Well, it was certainly outrageous, and when you look at, for example, out of Hillary's things as a woman
It really is.
and a physician, came what the insurance companies have done to pay for mammographies,
Yeah.
right? And the whole breast cancer issue is one I can speak for hours about. And it's hard.
But I was right.
Yes, you were.
I got it.
You were. I know.
Right.
I want to.
We'll pick it up.
This is the handshake that you made earlier.
Do you know what this is or no? About what? So this is a really cool thing. These are, oh, this is cool, right?
Bring back all the.
This is a certificate to get a screen for follow-up. These are limited run, extremely valuable. You have to go to this address. I know you're gonna be here till tomorrow, so you go. So it's, Melanie Myers. 65th High Street. No, this is the world. You get the take, green bag, green crab, let's say, or.
Yeah, that's what I'm doing.
I know.
Oh, that's a button right below.
Yeah, so if you go there and pick it up, the instructions in the back.
Well, there's.
Very cool.
Thank you.
These are very limited run by that.
Can we compare pictures of the two of you?
Oh, yes.
I will.
Yeah, it's what I've been doing.
It's
Exactly.
Of course, don't take for granted.
Stay still for a moment.
Okay, fine.
I have a mother too.
Thank you for all that you do.
I'll take a picture too.
For your time. Mr. Blackman, Professor.
Good job, guys. Enjoy the
Josh,
court.
fine.
Thank
you.
Okay,
ready?
Your building is beautiful.
Yes.
Very good, very good. What is your jurisdiction? You've probably never gotten that question by the scholars, I'm
But
sure.
not from high school.
Yeah.
That's right.
What's your jurisdiction?
You're welcome to come to front of me, if you're in town, moment.
Right, the three of you.
Thank you very much. Thank you.
You squeeze in just a little bit. All right, thank you. Okay.
All right, have fun in there.
So take it.
Hope so.